Today's presentation is titled Litigation and Claims Trends for the Life Sciences Industry, the 2017 Year in Review and Forecast for 2018. I'm Courtney Young, an attorney in Medmarc's Risk Management Department. On behalf of Medmarc and today's presenters, Sonia Valdes, Lisa Rice, and Laurie Sherwood, thank you for joining us. Sonia Valdes is Vice President of Claims for Medmarc Insurance Group in Chantilly, Virginia. She is responsible for medical device claim investigation and settlement oversight, defense counsel selection, litigation management, trial preparation and supervision, and claim reserve audits and assessments. Her responsibilities also include managing Medmarc's staff of claims professionals, overseeing of the claims department practices and procedures, and providing counsel to Medmarc's underwriters regarding life sciences, products liability, and litigation trends. In addition, Sonia has extensive experience in evaluating coverage and liability issues in environmental, mass tort, and drug and medical device litigation. Prior to her position at Medmarc, Sonia served as Worldwide Claims Manager for Chubb's Life Sciences line of business. Prior to Chubb, she held home office manager positions at Home Insurance Company and AIG. She was also previously employed in private practice, litigating personal injury and employment cases. Sonia is admitted to practice law in New Jersey and is a member of the IADC and ALFA. She received her undergraduate degree in biochemistry from Rutgers University and her law degree from Brooklyn Law School. She's a frequent speaker and contributor of articles on issues of interest to the life sciences industry. Lisa Rice is a partner at Walsworth and chair of the life sciences practice. Throughout her 20-plus year career, she has focused on products liability, life sciences, toxic tort, general liability, and business litigation. She has successfully represented a wide variety of entities, including manufacturers, distributors, premises owners, and large national retailers, in both individual lawsuits as well as multiple-party, complex, mass tort, and class action litigation involving medical devices, pharmaceutical products, herbal and dietary supplements, chemicals, metals, and other products. Lisa acts as both national and local counsel. Her record of success on dispositive motions and ability to negotiate favorable resolutions is recognized by client and opposing counsel alike. Laurie Sherwood is also a partner at Walsworth. She focuses her practice on life science litigation. For nearly 25 years, Laurie has successfully represented corporations, employers, manufacturers, and distributors in complex and multi-party federal and state litigation. She has tried cases to defense verdicts, arbitrated and mediated numerous cases, and engaged in effective law and motion practice. Her science background lends itself to her life sciences practice. She has successfully represented manufacturers, distributors, and retailers in litigation involving pharmaceutical products, herbal and dietary supplements and products, medical devices, and other related products. She takes a proactive and cost-effective approach to this litigation and seeks the most effective and beneficial resolution to her clients. Laurie manages all phases of litigation from pre-litigation to discovery and through ADR and trial. With that, I am pleased to turn things over to Sonia, who will begin today's presentation.
Thank you, Courtney. To those in our audience, welcome to our annual webinar summarizing the most significant developments of 2017 as it relates to the life sciences line of business. In addition to this summary, we will provide a forecast for what we believe to be the hot topics in 2018. Thank you for joining us. This is my fourth year in seminars since I joined Medmarc. I've truly enjoyed doing this. I hope you share my enthusiasm. The agenda will not deviate much from past years. We will focus on significant cases affecting the life sciences industry, discuss some noteworthy verdicts, and predict emerging trends. There's lots of ground to cover, so please kick us off, Laurie.
Thank you, Sonia. So first of all, good afternoon, and we're pleased to be able to present to you today. I would like to start off talking a little bit about updates from our new administration and the new FDA. Last year, Lisa and I were actually on the road visiting some life science clients when the election occurred, and the next day we were actually meeting with clients who readily pointed out, and the discussion came about the election and the impact on the life sciences and the pharmaceutical industry, with our clients noting they expected most likely less regulation and hopefully faster approvals. And we'll be talking a little bit about that today. So in the first 6 months, Mr. Gottlieb, as the FDA Commissioner, with an interesting background, he is a physician. He was a prior FDA Deputy Commissioner, and he has extensive ties to the pharmaceutical industry. So I think everyone was pleased, or I shouldn't say everyone, but definitely the industry was pleased with his appointment. He does, however, recognize that the FDA is unlike some of the other agencies that have been impacted by the Trump administration in that we have to balance business interests with safety of patients and consumers as well. So far, he has been a very active commissioner, especially he is very social media conscious. He blogs regularly. He posts on the FDA blog. He tweets regularly, averaging over 1,100 tweets so far, which is about 6 a day. And he has also issued a number of statements on various topics, especially within the last few months. There's been a regular issuance of statements, some of which I'll just briefly cover today. It's also been noted that he interacts more frequently and communicates directly with the pharma industry and medical device industry, and is actually meeting with fewer consumer groups than other prior commissioners. And I'm going to focus just on some of the areas where we've seen probably the most activity. One has been heading towards faster approvals. There had been some concern initially with the new administration and less regulation that there would be a breakdown, tear down of the agency. That has not happened. Again, there has to be that balance between business interests and consumer safety, but there have been faster approvals, and I'll talk about a statement that was just issued a couple of days ago. By way of example, in terms of changes in approvals and faster approvals, last year the FDA refused to consider the rare disease drug miglustat, indicating more research is required, but in July of this year, the FDA reversed course and accepted that drug. In September of this year, Mr. Gottlieb endorsed the greater use of seamless clinical trials, and that's been characterized as a new buzzword at the FDA, which does not use the three-step approach, but rather combines 2 or more phases into one adaptive design study. It's been noted that it's good for oncology drugs, will lead to quicker approvals, and may also likely lower prices if it's developed at less expense to the consumer. 2 days ago, and probably most importantly, he has proposed a new fast-track process for certain devices that currently do not meet the criteria under the current fast-track 510K pathway, and potential reductions in the amount of safety data required for approvals. It's been surmised that this could save the industry billions of dollars, or actually I should say millions of dollars, but there also has been a very quick response from the healthcare industry about safety concerns. This process may also apply to high-risk drugs, so we'll have to see how this proposal moves forward and whether it is approved. Moving on just quickly to device policies, there have been notable updates to medical device policies. Device approvals can now be supported by real-world evidence and specialized methods known as medical device development tools. In another area involving digital health products, which is obviously a key concern and key issue these days with all of the technology, in September, the FDA launched a pilot program where specific companies, including Apple and Fitbit as well as others, can be pre-certified as high-quality manufacturers of digital health products. Moving on, in these first 6 months, he has taken action on generics, and I'll just briefly mention opioids because Sonia's going to be spending a lot of time on that topic. But there have been aggressive measures and focus to bring drug prices down, which was one of President Trump's campaign promises, and this includes initiatives to spotlight 250 brand name drugs currently lacking generic competition, and to fast-track the approval of those generics that copy the name brand drugs, which will lead to more competition in the market. Interestingly, Mr. Gottlieb, in an interview with Bloomberg, was asked whether prices and the drug prices could be lowered by executive order, which has been a common method throughout this presidency so far. And Mr. Gottlieb simply referred the interviewer to the White House on that question, so would not answer it. So we kind of have addressed drug prices and regulation. Moving on just quickly to the FDA funding bill. President Trump would actually like to see the FDA 100% funded by fees. However, there is already a process and laws in place that address the funding of the FDA, so that is not possible at this point. But recently, the FDA Authorization Act of 2017 was passed, and that act has to be renewed every 5 years. And under that act, drug developers and manufacturers pay fees for every application for a new product, which then enables the FDA to hire more employees, which theoretically should speed up the approval process. And the president did sign that signed that act into law in 2017. And lastly, just challenges confronting the FDA under the Trump administration. There's a very good article and study that was a joint project with the Yale Medical School and the Yale School of Public Health that identified several areas moving forward that they think will be challenges for the FDA moving forward and in the future. And those include pre-market regulation of new medical products, post-market follow-up of medical products, pre-approval access to experimental therapies, use of real-world evidence, and avoiding low-quality real-world evidence, resisting efforts to weaken off-label marketing and the restrictions on that, and strengthening the regulation of medical devices, and finally, improving the access to clinical trial data, including patient-level data, summary-level data, and metadata. But given the flurry of activity and the number of statements from Mr. Gottlieb over the past few weeks, I would encourage everyone to keep an eye on the FDA, and it will be interesting to see where we go from here. But it definitely appears that faster approvals and less regulation are on the horizon. So with that, I will turn it over to Lisa.
Thanks, Laurie. I'm going to talk a little bit about some Supreme Court decisions this year. We saw two pivotal decisions which really clarify the limits of personal jurisdiction and provide defendants with some ammunition to defend against litigation tourism. The first case is BNSF Railway versus Tyrell, which was decided on May 30th of this year. And this case addressed general or all-purpose jurisdiction. The case involved employees' claims under the FELA, which is the Federal Employers Liability Act, and it was brought in Montana State Court. The plaintiff employees in that case, they didn't live in Montana, they weren't injured there, and their employer was not incorporated there, nor did it have its principal place of business there. However, the Montana Supreme Court found that the exercise of jurisdiction was proper. The U.S. Supreme Court reversed, and in an 8-1 decision, Justice Ginsburg, who wrote for the majority, made it clear that if a defendant is not at home in the forum state, that general jurisdiction is not appropriate. The court defined at home for a corporation as the place of incorporation and its principal place of business. And so the court really focused, or they said the focus is not so much on the extent of defendant's in-state contacts. Indeed, the court acknowledged that a corporation can operate in many places, but can't be considered at home in all of them. The second case is Bristol-Myers Squibb versus Superior Court, decided in June, so less than a month later. This time the court turned its attention to specific or case-linked jurisdiction, and the claims in that case belong to non-California residents who joined a mass tort action in California against BMS, Bristol-Myers Squibb, who is the manufacturer of a drug called Plavix. BMS was neither incorporated in California nor had its principal place of business there, but it did do significant business there, including a high volume of sales of Plavix in California, but it didn't manufacture or develop the drug in California or seek regulatory approvals there. The non-California plaintiffs didn't buy Plavix in California, they didn't ingest it there, and they didn't allege that they were injured in California. The California Supreme Court applied what it called a sliding scale approach to jurisdiction and found that specific jurisdiction did exist. But the Supreme Court of the United States expressly rejected this approach and emphasized that the focus really should be on the connection between the plaintiff's claim and the forum, rather than defendant's contacts with the forum. This was another 8-to-1 decision. This time, Justice Alito wrote for the majority, and the court held that specific jurisdiction requires a connection between the forum and the specific claims at issue, and a defendant's unrelated contacts with the forum are irrelevant to the specific jurisdiction analysis. So how have courts been applying these rulings since they were issued? In June, on June 27th, so about a week after the BMS decision, a federal judge in the Eastern District of Missouri dismissed the claims of 86 non-Missouri plaintiffs who sued the manufacturer of an anti-clotting drug in Missouri State Court. Relying on BMS, the court found that Missouri lacked personal jurisdiction over defendants and dismissed the claims of those 86 non-Missouri plaintiffs. Then, in September, another federal judge in Missouri dismissed the claims of 79 out of 83 plaintiffs from 30 different states against a New Jersey-based talcum powder manufacturer. In October, Johnson & Johnson won an appeal of a $72 million verdict in a claim that its talc products caused plaintiffs ovarian cancer. The Missouri Appeals Court found the case shouldn't have been tried in Missouri. And again, relying on the BMS case, the Bristol-Myers case, the appeals court found that the Alabama plaintiff who was the subject of that lawsuit didn't meet the standard outlined in the Bristol-Myers case. So we had a couple of good decisions for the defense, but more recently there have been some decisions that have been more favorable to the plaintiffs. On November 30th, a Missouri appeals court upheld a $110 million jury verdict in a talc cancer case. The court determined that the verdict in favor of a Virginia plaintiff met the stricter jurisdictional standards established in the Bristol-Myers ruling. In that particular case, the defendant, Johnson & Johnson, used a company based in Missouri to manufacture, label, and package the products at issue. So the court found that jurisdiction did indeed exist over the defendants. And then last week, on December 5th, a Pennsylvania state court affirmed jurisdiction over 70 pelvic mesh cases involving out-of-state residents. The judge issued a one-page order with really not much of an explanation, but what we do know is that the products implanted in 70 of the 71 plaintiffs were made using a mesh manufactured by a company in Pennsylvania. Only one of the plaintiffs was implanted with a product that had mesh manufactured by a different company not in Pennsylvania, and that one claim was dismissed. So the common thread between the last two cases is that the defendants had used companies in the forum state to manufacture the products at issue. And at least in Missouri and Pennsylvania, this appears to have been an adequate link between the plaintiff's claims and the forum to affirm specific personal jurisdiction. So with that, I'm going to turn it over to Sonia now, who's going to talk about our next topic, opioids.
Thank you, Lisa. You've heard a lot about opioid addiction crisis in the news. I'm just going to just bring to your attention a couple of newsworthy articles. In July of 2017, the FDA asked Endo Pharmaceuticals to remove its painkiller Opana extended release due to abuse risk. Although reformulated by Endo to prevent crushing or snorting, users had turned to liquefying and injecting the drug in a method that had been connected to a serious outbreak of HIV and Hep C. In August of 2017, the DOJ announced ramped-up efforts to fight the opioid crisis by starting a 12-attorney unit to investigate and prosecute healthcare fraud involving prescription opioids. Attorneys were appointed to permanent 3-year positions. The goal was to use data to prosecute players in the pill mill chain. More recently, on October 15th, the news show 60 Minutes ran the results of a 6-month joint investigation with the Washington Post into the causes of the opioid epidemic facing this country. Their conclusion was that the drug companies, with the assistance of Congress, who turned a blind eye to diversion, were the real culprits behind the spread of this epidemic. That members of Congress worked with major drug manufacturers and distributors to weaken any enforcement by the FDA and others. The report pointed out sympathetic members of Congress, such as Pennsylvania Congressman Tom Marino, who allegedly shielded the drug companies' international business schemes to increase opioid sales. Tom Marino was nominated to be the nation's drug czar by President Trump, but withdrew his nomination shortly after the 60 Minutes piece. Lastly, on October 26th, the Trump administration responded with a declaration that the opioid epidemic constituted a public health emergency, but not a national emergency. No new funding was unveiled. Instead, the administration touted expanded access to telemedicine and speedier hiring of medical professionals working on opioid issues. Congress is slated to spend $500 million a year on addiction treatment this year. The money runs out for 2018. There seems to be no real groundswell to work on the issue of additional funding. So look for the FDA to lead the response to the epidemic by providing long-term access to drugs to treat opioid addiction and using other tools to address the crisis. So how bad is the opioid addiction crisis? The statistics are staggering. 91 people today will die, just today, due to opioid overdoses. In 2016, we had more than 60,000 people who died. The costs, in 2017, the expenditures for opioid addiction will hit $78.5 billion. The manufacturers of opioids are reaping about $13 billion in profits a year. And then there are these glaring examples of abuse of opioids. Kennett, West Virginia is a tiny town that has 392 residents, yet there are 9 million prescriptions of hydrocodone filled during a 2-year period in Kennett, West Virginia. And in Ohio, it is estimated that 20% of the population of the state of Ohio has been prescribed an opioid. So let's talk a little bit about the actions that are pending. There are over 100 lawsuits. There are at least 8 lawsuits filed by the states through their attorney generals at present. 41 states have also issued subpoenas to 4 major drug manufacturers: Endo, J&J's Janssen unit, Teva, and Allergan. West Virginia filed against the manufacturing distributors first, followed by Ohio and Kentucky. These states are ground zero for the opioid addiction epidemic. But not to be in the foreground, counties in California, West Virginia, Oregon, Pennsylvania, and New York have also filed suit, along with at least 10 cities, including Chicago, Birmingham, and Newark. There's also been a fairly recent action by 2 Indian tribes against the manufacturers and distributors of opioids. The allegations against the defendants are that they purposely minimized and concealed and misrepresented the addictive nature of the drugs and kept the epidemic growing by flooding the tribes with these drugs. There's also been at least 1 putative class action filed in Arkansas, the Lewis case. Lewis was filed by an attorney who became addicted to opioids when they were prescribed to treat his orthopedic issues. The action alleges that the defendants forced doctors to overprescribing these drugs and downplayed the addictive nature of these drugs. It seeks compensatory damages, but also the creation of a medical monitoring fund. More recently, 2 Florida hospitals have filed lawsuits against manufacturers and distributors for contributing to the crisis by filling suspicious orders and downplaying the risk of these painkillers. Lastly, the Teamsters Union has filed suit against manufacturers of certain opioids for having to pay for these opioids as part of their prescription coverage. They allege RICO marketing practices by the defendants, claiming that drugs were safe for long-term use. There have been very few settlements in the opioid litigation. It should be noticed that the few settlements have been led by Purdue Pharma, who has been the target defendant from the beginning. It is rumored that Purdue is working on a global settlement of all of its opioid issues or opioid exposures. And the last bullet, the Department of Justice filed a complaint against McKesson arising out of its failure to report suspicious orders of pharmaceutical drugs, including opioids. That case was settled earlier in January of 2017 for $150 million. So what are the allegations against the opioid defendants? Well, against the manufacturers, they focus on fraudulent and illegal marketing practices, violations of consumer protection statutes, fraud, public nuisance, and unjust enrichment. Against the pharmacies and drug distributors who have similar responsibilities, the allegations are similar. Arguments that the pharmacy and the distributor should investigate doctors who prescribe opioids illegally. The defendants must determine if there is a legitimate medical purpose to the script and must determine if the customer is doctor shopping. These are what the different plaintiffs have alleged against the pharmacies and drug distributors. I will say that these are difficult duties to comply with, so that these particular entities, the pharmacies and the drug distributors, are in quite a bind. Some pharmacies in rural or low population areas where the amount of opioids sold are greater than the population have been termed pill mills and have been particularly prosecuted by the state of West Virginia. Moving on to doctors, they are becoming increasingly being held liable, some even facing murder charges when their patients overdose on opioid painkillers that they prescribe. Between 2011 and 2016, the number of doctors punished by the DEA jumped more than fivefold. The DEA took action against 479 doctors in 2016, mostly for overprescribing and fraud. Overprescribing is an enormous problem. In 2010, doctors wrote enough prescriptions for hydrocodone to give every American adult a 30-day supply. Yet criminal charges against doctors remain relatively rare. However, as previously discussed, actions for overprescribing and not meeting the standard of care are increasing very significantly for doctors. Okay, so let's talk a little bit about some of the allegations from the main three states. West Virginia started it all. It alleges cost to treat the drug addiction problem, $430 million in 2010. That number has skyrocketed to $695 million by 2017. They have already received a significant payout for their lawsuit against the major wholesale distributors, and they've also settled with Purdue. Now the state of West Virginia is going after other parties, Endo and other manufacturers. And shortly after West Virginia settled with the wholesale distributors, at least 4 counties in West Virginia started began different complaints against the distributors seeking as damages a comprehensive response to the opioid crisis. The Ohio complaint details expenses of $175 million to purchase opioids as part of its health care coverage to its citizens, and another $110 in addiction treatment and $462 in medical treatment and counseling. The allegations against the manufacturers are for aggressively and deceptively promoting its products. Kentucky's only sued Endo at present as a manufacturer because it's already settled with Purdue, but it's again the same type of allegation that the opioids were safe for long-term usage. Within this multitude of wide-ranging allegations and different demands for damages, it was somewhat surprising that the Joint Panel on Multi-District Litigation created a multi-district litigation court to address the opioid addiction epidemic. Over 115 cases qualify to transfer to the newly created MDL, which is created on December 6th. Qualifying cases include cases against manufacturers, distributors, and pharmacies. So many different defendants that Judge Polster, the judge assigned to the MDL, has already indicated he will run the litigation on multiple tracks, perhaps based on the role of defendant. Now, several commentators have likened the opioid crisis to the new tobacco. Surely there are similarities. The tobacco litigation was principally brought by state attorney generals and health care advocates. The tobacco litigation was filed to reform the marketing practices of the industries, and the allegations are very similar to those against the opioids manufacturers. But there are some important distinctions too. The tobacco litigation involved a product that had no redeeming values and actually harmed a person's health. Opioids can relieve pain if prescribed and used correctly. Also, the tobacco litigation involved 4 or 5 defendants, not the long list of defendants that we are seeing in the opioid litigation. In the tobacco litigation, the presidential administration was clearly on the side of the plaintiffs in tobacco. Not really the case here. Lastly, the tobacco plaintiffs were greatly aided by statistical modeling from the University of California on tobacco-related costs compared to the overall health care costs. So in conclusion, I say they may be the new tobacco. Stay tuned. It's still too early to make a definitive diagnosis. There are a number of coverage issues associated with the opioid epidemic. I've listed for you a couple of them, but generally I want to just speak to how the complaints have evolved. Since the first complaints were filed, the various states and other entities have subscribed to a tactic that I call trial by complaint. The more recent complaints speak to the illegal, intentional, and fraudulent marketing practices of the manufacturers and willful and lax conduct on the part of the distributors. They even include outrageous facts to make the defendant's conduct look more intentional and wrongful. The state's claims include conspiracy, fraudulent schemes, and coordinated effort. These claims undercut any argument by the insureds that there has been an occurrence under the policy. What the plaintiffs, who are states, counties, cities, and their private law firms, are doing are pleading defendants right out of any coverage by virtue of taking this tact on the complaints. There's really nothing accidental or fortuitous in the recent complaints filed, which is just what an appellate court in California, a notoriously pro-policyholder jurisdiction, determined in the Travelers v. Activist case last month. So that kind of addresses the second and third bullets of the coverage issues that I put on your screen. Regarding bullet 1, the H.D. Smith case, Seventh Circuit Court of Appeals case, the court held that it does not matter if West Virginia is seeking recovery of amounts paid to compensate the injured drug users themselves, or alternately seeking reimbursement of expenses incurred by the state. Both payments, the court argued, implicate bodily injury coverage, since the payments were made because of bodily injury, therefore requiring the insured to defend. Note the key difference is in the terms "because of bodily injuries" as opposed to "for bodily injury." If the "for bodily injury" language were used in the insuring contract in the H.D. Smith case, as it was at issue in the Florida case, Travelers v. Anda, a 2016 case, there might well have been a different result in the H.D. Smith case. The Florida court also ruled there was no coverage because West Virginia's alleged damages were for its own economic loss rather than for bodily injury of its residents. Lastly, how many occurrences? It's an old question. Is the number of occurrences measured per dose, per prescription filled, or per person? Or is it even one occurrence based on the allegations of concerted conduct by the manufacturers and distributors? The answer is, who knows? It depends on the case law in the jurisdiction applicable. I am aware that many carriers are starting to draft opioid exclusions for fear that anyone tangentially involved in the opioid crisis would seek insurance coverage for these cases. So that seems to be the new rage in coverage, is trying to draft opioid exclusions. Shifting gears a little bit, I want to talk to you about the new Judicial Hellholes, which came out last week. The Judicial Hellholes list is published yearly by ACTRA, American Trial Reform Association. The new list has Florida in first place, but I won't spend too much time on Florida because it's not particularly inhospitable place for drug or device companies. California is still number 2 due to its consumer protective judiciary, but it has lost a lot of cases it had in the state MDL due to Supreme Court decisions on jurisdictions. California is actively dismissing cases based on jurisdictional grounds. The one jurisdiction that has shot up the list is the Court of Common Pleas in Philadelphia. The state MDL is known for its huge verdicts in product litigation. There have been excess verdicts in pelvic mesh, where the defendants have lost 4 cases in a row, Risperdal, and finally Xarelto. The Xarelto defendants were undefeated, having won 3 cases until they got to Philadelphia. In their first case in Philly, they were hit with a $28 million verdict. On the positive side, at least they weren't hit with punitives, which is becoming more the norm in the Pennsylvania MDL. Part of the problem is Judge New, who was really thought to be a savior at the Philadelphia MDL, and he seems to have really changed course. He has, as Lisa alluded to, not dismissed many of the cases that the defendants thought should be removed to other jurisdictions. And the other thing that makes the Philadelphia MDL particularly problematic is that Pennsylvania does not recognize preemption defense for failure to warn or design defect allegations. So these very significant defenses are not available in Pennsylvania. For life sciences companies, I think it's clear that the worst judicial hellhole is clearly the Pennsylvania MDL in Philadelphia. Moving on to the judicial hellholes watch list, the dishonorable mention, there are the usual suspects, particularly West Virginia and the Ninth Circuit, which has overtaken the California Supreme Court for dishonorable mention. The one jurisdiction is missing from the list is the Delaware trial courts. Delaware has recently become a pro-plaintiff state, much to the detriment of defendants, many of whom are incorporated there and thus subject to jurisdiction in the Delaware State Court. What makes Delaware awful? Let's look at punitive damages. While there is a standard of clear and convincing evidence required to maintain a punitive damages award, there is a sliding standard of what conduct complies with this clear and convincing burden. Also, punitive damages are available for a wide range of actions, particularly those that are consumer-oriented, such as actions for reporting by credit agency, fair housing, and even insurer bad faith. There are no caps to punitive awards in Delaware, and there does not need to be a ratio between compensatory and punitive damages. You can get an award of punitive damages without an award of compensatory damages. And so I'm going to turn this over to Laurie now.
Thank you, Sonia. So moving on to some of the significant verdicts, both plaintiffs and defense, and significant decisions over the last year, I'm going to go ahead and cover devices and then turn it over to Lisa to talk about drug verdicts and decisions. So starting off with pelvic mesh, which just looking at the slide confirms what Sonia just said about Philadelphia. Basically, pelvic mesh is used for transvaginal mesh surgery and bladder slings to repair weak or damaged tissue, which results from pelvic organ prolapse or stress urinary incontinence. There have been hundreds of thousands or 100,000 cases. There is an MDL that is pending in the federal court in the Southern District of West Virginia, overseen by Judge Goodwin, and there have been a number of decisions there. We're going to focus on some of these key plaintiff wins. The first one, a $20 million verdict against J&J in April of 2017, comprised of $17.5 million in punitive damages and $2.5 in compensatory damages. The jury found defective design, warning, and instruction, and that Ethicon had released the product despite knowing of significant risks resulting in mesh erosion inside the patient. This particular patient underwent 3 surgeries, and portions of the mesh remained inside her body. The next verdict was a $2 million verdict against J&J, same court in May of 2017. No punitive damages were awarded in this one. Here, the jury found that the risks of the product outweighed the benefits and were responsible for plaintiff's chronic vaginal pain, but actually found that the product performed as expected and that the surgeon had been warned of the risks. The next verdict in July of 2017, which was actually against J&J, was overturned. So originally, the jury found that the product was defective and failed to provide adequate warnings, but found no causation between the actual product and the mesh erosion experienced by the plaintiff. And declined to find that she suffered actually any injuries as a result of the product. In post-trial motions, however, the judge reversed the verdict partially and ordered a new trial on damages because the jury had found a defective product and failure to warn. The next verdict, again from the Philadelphia Court of Common Pleas, was a $57 million verdict against J&J. In this case, the plaintiff had sustained a scarred urethra, which caused urinary incontinence. She had undergone a number of surgeries, and this was a unanimous verdict and included $10 million in punitive damages. And lastly, a $3 million verdict against Ethicon was allowed to stand, although they appealed or attempted to appeal to the U.S. Supreme Court. In October of this year, the court denied cert. And lastly, on the pelvic mesh issue, Endo has paid $750 million to end virtually all known mesh product liability claims. They expect that they will actually pay out $775 million to resolve all U.S. and international claims, as well as to cover costs. So now moving on to hernia mesh. Hernia mesh has been used for over 50 years in repairing hernias, and it provides additional support to damaged or weakened tissue. When things don't go correctly, it can cause infections and other physical problems. We do have a defense win here, which is always nice to see, and in this case, the court granted summary judgment in favor C.R. Bard in the Southern District of Illinois in February of 2017. This was a wrongful death case involving a mother. They alleged that her death was caused by sepsis, which was caused by the defective Bard hernia patch. Plaintiffs claimed that Bard had ignored buckling problems with the patch, but the patch had actually been recalled 5 months after her death. The court granted the motion on the basis that one of plaintiff's experts was not reliable and the other expert was not qualified to opine on causation. The expert that was deemed not reliable had attempted to rely on experience based only with his own patients. He had come up with a theory referred to as the nidus theory, but this theory, however, was not described in medical literature, had not been peer-reviewed, and the plaintiff herself on autopsy and in the medical records did not have the symptoms the purported expert associated with his theory. There have been some recent suits filed in New York and New Hampshire involving the Ethicon PhysioMesh product as well as the Atrium CQUR mesh. Interestingly, in the Atrium case, it's a little bit different. That product there is actually coated with fish oil, which has caused allergic reactions in some plaintiffs, resulting in inflammatory conditions, although there have been warnings that that product should not be used in people who have fish allergies. Moving on next to the Da Vinci surgical systems, which are basically robotic systems developed by Intuitive, and they're used for complex, minimally invasive surgeries in which tiny multi-armed instruments are inserted into the person's body and computer-controlled by small movements by the surgeons. There is a plaintiff win in the Washington Supreme Court. In this case, it was a prostate cancer patient, and Intuitive actually won a jury trial in that case. The judge later vacated the verdict, finding that Intuitive had a duty to warn the hospital and or the medical center, which essentially is imposing or broadening the duty to warn. And in this case, Intuitive had when they sent the product to the center and to the physician, it was accompanied by the manual. The manuals and the instructions were provided to the surgeons who would be using the actual Da Vinci surgical system, but the court found that that wasn't sufficient, that the hospital or medical center should have also been provided those materials and had a duty to warn. This does raise questions, and we'll have to continue to monitor this moving forward about the learned intermediary, as well as who is the actual purchaser under the circumstances. And in reaching this decision, the court relied on policy and logic as well as dicta from other cases. There have been, luckily, a couple of defense wins involving the Da Vinci surgical system. I'm going to kind of just lump them both together in the interest of time and convenience, but both involve medical fragments or medical microscopic particles that are being leached from the surgical instruments and end up traveling to the person's brain. There have been no actual damages or injuries, and no one's been able to actually identify what could go wrong. So both cases have been dismissed as a result of there really being no injury. And additionally, Intuitive does have warnings that these metal or metallic particles can travel to the heart, so there has been some warning. These cases were both filed as class actions, but both were dismissed. Moving on to knee implants, which have become very commonplace, and just some quick statistics. Last year, there were 700,000 knee replacement surgeries performed in the U.S. That number is expected to increase to 3.48 million annually by 2030. and this involves resurfacing the knee with artificial components. We have a defense verdict in favor of Zimmer in the Northern District of Illinois in January 2017. This was the third bellwether trial. The surgery failed and the plaintiff required revision surgery. She claimed that the doctor had not properly warned her that obese surgeons were subject to risks of failure on knee replacements. However, the literature showed that this was discussed in the literature, in the warnings, that there are risks to obese patients and how doctors should handle cases involving obese patients. Here, too, it was noted that the plaintiff had actually gained significant weight following the actual surgery, which could have resulted in the failure of the knee. March of 2017, summary judgment was granted in 137 lawsuits in favor of Zimmer. Here, the plaintiffs had alleged that the knee was unstable when extended to full range of motion. However, the plaintiff failed to provide any expert evidence to support this theory and to support that the patients actually experienced instability and high flexion as a result of the knee. The court had noted and had requested that they needed to present, or the plaintiffs needed to present, expert evidence to create a triable issue of fact under state law. They failed to do that, and summary judgment was granted. Lastly, moving to hip implants, which are not quite as common. There were 200,000 last year, or 200,000 plus, expected to grow to 572,000 by 2030. We do have a defense win in the Eastern District of Texas in May of 2017 involving a Zimmer product. The court found, or the jury found, no manufacturing defect or no violation of the Deceptive Trade Practices Act. The product itself had actually been recalled in 2012. There have been some substantial plaintiffs' verdicts. The first one, a $1 billion verdict against J&J in the Northern District of Texas in January of 2017. This was the third bellwether trial for the product. There were 6 plaintiffs. Originally, there were $32 million in compensatory, $1 billion in punies. The damage award, however, was cut by the judge and reduced to nearly half, to a total of $543 million for the 6 plaintiffs. Here, the plaintiffs alleged that there was tissue death, bone erosion, and they claimed that J&J and Ethicon rushed the hip through to market. The plaintiffs have appealed the reduction of the verdict. There was also a $2 million verdict against Zimmer in the 2nd Judicial District of New Mexico in March of 2017. Here, the plaintiff alleged a condition known as metallosis, which is caused by metal-on-metal rubbing, which releases particles that ultimately led to an infection, and this was actually a bench trial. And lastly, a $247 million verdict against J&J in the Northern District of Texas. So on the hips, Texas seems to be the favorable jurisdiction to plaintiffs. This was the November 2017 decision or verdict involving 6 plaintiffs, design, manufacturing, deceptive business practices, and allegations of wanton, reckless, and malicious conduct. There was a $90 million punitive award against J&J, a $78 million punitive award against Dupuis, and $77 million in compensatory to cover past, future medicals, pain and suffering, etc. And with that, I will turn it over to Lisa to talk about drug verdicts.
Thanks, Laurie. In 2017, there were a number of noteworthy verdicts, judgments, and other rulings involving pharmaceutical products. And the first one I want to talk about is Risperdal. Risperdal is an antipsychotic medication. It's used to treat schizophrenia and bipolar disorder in adults and children. It may also be used to treat symptoms of irritability in some autistic children. It's also frequently prescribed off-label to treat ADHD, which is an unapproved use. It's been alleged to cause a condition called gynecomastia, or male breast growth. It's also the subject of a mass tort program in Philadelphia, which now includes some 6,400 cases. So let's start with the good news, the defense wins. In March, a Pennsylvania state court granted summary judgment in favor of J&J and Janssen in a lawsuit brought by the family of a young boy over abnormal breast growth after using Risperdal. The plaintiff was prescribed Risperdal when he was 8 years old to treat symptoms of ADHD, and the court's ruling was based on the testimony by the plaintiff's treating physician and the learned intermediary doctrine. The court found that plaintiff was not able to establish that a different warning would have changed the physician's treatment plan. In October, the Mississippi Supreme Court overturned a $2 million jury verdict. The plaintiff there was prescribed Risperdal to treat her severe depression and psychosis. Warnings that accompanied the drug included potential side effects, including a movement disorder. After her doctor increased the dosage of her medication multiple times, the plaintiff developed the movement disorder. And at trial, the jury determined that plaintiff's injuries from Risperdal were due to the manufacturer's failure to provide adequate warnings and its negligent marketing, again awarding $2 million in damages. But the Mississippi Supreme Court reversed and found that the drug's label sufficiently warned about the associated risks and ordered a new trial over the allegation that the manufacturer had misrepresented the treatment to a physician. In November, a Pennsylvania appeals court found that Michigan residents were barred by Michigan law from pursuing claims in a Philadelphia mass tort action that they grew breasts after taking Risperdal as young boys. The court held that the Michigan Product Liability Act, which is a statute that bars claims over drugs that have been approved by the FDA, foreclosed these plaintiffs' cases despite the fact that the medication was actually being used off-label. And looking at the plaintiff's successes, in November, the Pennsylvania Superior Court reversed Janssen's only defense verdict in Risperdal mass tort litigation in Philadelphia. The Superior Court found that the trial court erred by permitting a physician's assistant who treated the plaintiff for 8 years to offer expert testimony at trial. Now moving on to the next drug, Depakote. That's an anti-seizure medication that is alleged to cause birth defects, including heart defects and developmental delays. Again, starting with the defense wins, in February, a federal jury in the Northern District of Ohio reached a defense verdict for Abbott. Plaintiffs alleged that their son's birth defects were the result of his mother taking Depakote while pregnant. The jury found that plaintiffs failed to prove that Abbott did not provide adequate warnings about the risks of Depakote or that the drug was otherwise defective in any manner. And in mid-November, a federal court in the Southern District of Illinois granted summary judgment in favor of Abbott. Plaintiff sued Abbott alleging that her use of Depakote while pregnant caused her child's spina bifida, learning disabilities, developmental delay, ADHD, and various other quite serious conditions. The judge found that plaintiff failed to provide expert testimony to prove proximate causation with respect to the claim related to her son's autism. So that claim was tossed out. Looking at the plaintiff wins, an Illinois federal jury in June found that Abbott failed to warn doctors about the risk of a severe birth defect in the babies of women who took the drug while pregnant, and awarded a 10-year-old boy born with spina bifida $15 million. Interestingly, though, the jury declined to award punitive damages. In September, the Supreme Court of Missouri affirmed a $38 million verdict for a plaintiff born with spina bifida and other birth defects and severe cognitive impairment. The court ruled that there was evidence to support that Abbott knew the birth defect risk surpassed what it had actually listed on the drug's warning label. In September, a federal court in the Southern District of Illinois denied Abbott's motion to dismiss the claims of a mother who claimed her child's spina bifida and other physical and cognitive injuries were caused by her use of Depakote. Next, we're going to move on to Xarelto, which is a blood thinner, and it's linked to claims of excessive bleeding. And there is an MDL in federal court in Illinois over the Xarelto litigation. Again, starting with the defense wins, Baer and Janssen won defense verdicts in the first 3 bellwether trials in the multi-district litigation pending in Louisiana over unstoppable bleeding allegedly caused by the drug. The first verdict involved claims by a 75-year-old man who began taking Xarelto to control his atrial fibrillation, and less than a month later he was hospitalized for dangerous gastrointestinal bleeding and required multiple blood transfusions. The jury found that the drug manufacturers did not fail to provide adequate instructions for the safe use of Xarelto. And the second defense verdict was in June in federal court in Louisiana. Plaintiff was a widower who claimed that the companies failed to warn doctors of Xarelto's dangers and therefore were responsible for the stroke that killed his wife. But again, they got a defense verdict in that case. And the third defense verdict came in August, this time by a federal jury in Mississippi. The trial was actually presided over by a Louisiana federal judge, but the trial itself took place in Jackson, Mississippi. In that case, the plaintiff had developed deep vein thrombosis after a hip replacement. She was given Xarelto to treat a DVT, but as she was taking it, she started having gastrointestinal bleeding and had to be hospitalized. The jury in that case found that defendants did not fail to provide her doctor with adequate instructions for its safe use. But the plaintiffs have had some wins as well. In fact, after the string of those defense verdicts that we just discussed, last week on December 5th, defendants faced their first loss when a Philadelphia jury found the companies provided inadequate warnings about the risks of bleeding associated with the drug. $28 million was awarded against Johnson & Johnson and Bayer, and $26 million of that was for punitive damages. However, the fate of that verdict really is uncertain because it was given despite testimony from plaintiff's physician that additional warnings about the drug's risk of internal bleeding would not have changed her prescribing decision. So defendants intend to appeal in light of that testimony. And this is really one of about 1,500 pending cases in a mass tort program in Philadelphia County, and another Xarelto case is scheduled to go to trial in Philadelphia in January. I'd also just like to mention that in November, a Pennsylvania state court denied Johnson & Johnson and Bayer's motion to dismiss, ruling that failure to warn claims in the mass tort litigation in Philadelphia were not preempted by federal law. Next, I want to talk about the testosterone replacement drugs. There are a number of them that are in litigation, and the claim is that those drugs are linked to heart attacks. With the defense wins in August, AbbVie, who is the manufacturer of Androgel, got its first defense verdict in Illinois State Court. That was on August 31st. Plaintiff claims he suffered a heart attack after taking Androgel. He sought $28 million in compensatory damages plus punitive damages. AbbVie argued that plaintiff barely used the Androgel. He had only filled his prescription twice between the time he received it and the time he had his heart attack, and he had stopped taking it 2 months before the heart attack. The jury rejected plaintiff's claim that defendants failed to warn him and his doctor about risks that accompany the drug. And in mid-November, Auxilium, another manufacturer of a drug called Testim, got a defense verdict in federal court in the Northern District of Illinois. Plaintiff in that case sued Auxilium after he suffered a heart attack while working in his yard. He had been using Testim for about 7 months, and he claimed that the company was pushing doctors to test their male patients' testosterone levels and prescribing the drug if they were low. And testosterone levels normally drop with age, but the plaintiffs argued that the drug wasn't approved for such a general use. Auxilium argued that the FDA had approved its label and advertising, and that plaintiff's heart attack was really related to some conditions that he had before he started taking the drug, such as diabetes, obesity, and high cholesterol. Turning to the plaintiff's wins in the testosterone replacement litigation, in July, a federal jury in the Northern District of Illinois returned a $150 million verdict against AbbVie for the Androgel. Plaintiff sued after he suffered a heart attack while using Androgel. He claimed the company downplayed the risks of testosterone replacement and specifically marketed Androgel to men whose drop in testosterone was tied to age or obesity. Interestingly, in this case, the jury didn't award plaintiff any compensatory damages, finding that Androgel didn't cause any damage. But the jury still hit AbbVie with $150 million in punitive damages, finding that company officials made fraudulent misrepresentations about the product's safety. In October, we saw another plaintiff verdict for Androgel in the Northern District of Illinois. Plaintiff had a heart attack, which he linked to Androgel. He was prescribed the drug 65 days before his heart attack, and the plaintiff claimed that the company, again, promoted the drug to aging men without mentioning known risks or doing proper testing. The jury awarded plaintiff $140,000 in compensatory damages, but hit them with a huge punitive damages award of $140 million. Next, I'm going to address Zoloft, which is an antidepressant, and it's alleged to cause heart defects in babies whose mother used the drug during pregnancy. For the defense, in February, summary judgment was granted for Pfizer in 2 West Virginia birth defect cases. The plaintiffs were parents of 2 children who sued Pfizer, alleging that their mother's use of Zoloft during pregnancy caused heart defects in their children. The plaintiffs alleged that Pfizer failed to adequately warn about the risk of birth defects. Plaintiffs had some trouble producing a labeling expert in that case, and after a couple of failed attempts, the court found that they were unable to meet their burden of proof on the adequacy of the Zoloft warning label. The plaintiffs tried to argue that they could rely on Pfizer's witnesses to provide expert testimony, but the court rejected that argument. In June, Pfizer had another win when the Third Circuit upheld a lower court's decision to exclude the testimony of a statistician and granted Pfizer summary judgment in more than 300 cases, finding that the expert's methods were unreliable. I just want to give a brief mention to the defense verdict in the Motrin cases. Motrin is an over-the-counter, non-steroidal anti-inflammatory drug and pain-relieving medication. On July 3rd, a court of appeals in California granted Johnson & Johnson subsidiary McNeil a new trial in a case in which a man was awarded $48 million after he developed a very serious skin condition from taking Motrin. In 2011, jurors awarded the plaintiff about $32 million in compensatory damages and $16 million in punitive damages. The appeals court found that the jury's finding of a design defect in Motrin was preempted by federal law. I want to shift gears real quick to briefly mention the talc verdicts. Talc cases involve claims against makers of cosmetic talc, which is basically baby powder, alleging that those products cause ovarian cancer, and also more recently claims of asbestos-related diseases such as mesothelioma, which allege that the talc in the products was contaminated with asbestos. In May, a plaintiff's win, a Missouri federal jury ordered Johnson & Johnson to pay $110 million to a woman alleging that the talcum powder products that she used caused her ovarian tumors. The plaintiff was a resident of Virginia. She alleged she developed ovarian cancer after using the products on a daily basis for 40 years. Of the $110 million awarded, $5 million of that was compensatory damages and the rest was for punitive damages. We did talk about this briefly in our prior discussion about personal jurisdiction, and the Missouri Appeals Court recently upheld the verdict in November, finding that the Missouri court did indeed have jurisdiction over the Virginia plaintiff's claims. In terms of defense wins, in March, jurors in Missouri returned a defense verdict on another ovarian cancer claim. The jury found that the plaintiff in that case was just unable to prove her claim that her disease was connected to her 38 years of daily use of talcum powder. And in October, Johnson & Johnson won its appeal of a $72 million verdict claiming that its talc products caused ovarian cancer. Again, we briefly touched on this case in our personal jurisdiction discussion, and the Missouri Appeals Court found that the case should not have been tried in a St. Louis court. Also in October, a few days later, the Los Angeles Superior Court reversed a jury award of $417 million. Of that amount, $347 million was punitive damages for a woman who claimed Johnson & Johnson's baby powder gave her ovarian cancer. The court found that plaintiff relied on speculative expert testimony that failed to link talcum powder to cancer. And the judge entered a JNOV, or judgment for defendants notwithstanding the verdict, on the grounds that specific causation had not been shown, and the court also ruled that punitive damages had not been warranted since no malice was demonstrated. And in November, on November 16th, Johnson & Johnson won a defense verdict in Los Angeles. This time this was a mesothelioma case. The plaintiff in that case sued Johnson & Johnson and its talc supplier for her terminal mesothelioma. The jury found that Johnson & Johnson did not negligently design or sell its talc, and that the talc did not fail to perform as safely as a reasonable consumer would have expected. The jury also found the talc was not defective and that Johnson & Johnson did not fail to warn. And now I'm going to turn it back to Laurie, who's going to begin our next discussion on regulatory actions.
Thank you, Lisa. So firstly, we'll go through these fairly quickly, but the first one is the final guidance issued in 2017 regarding the assessment of abuse potential of drugs. And this guidance is intended to assist sponsors of investigational new drugs and applicants for approval of a new drug in evaluating whether the drug product has abuse potential. This guidance also provides recommendations to applicants who intend to submit new drug applications for prescription drug products that may have abuse potential. Generally, drug products with abuse potential contain drug substances that have central nervous system activity and produce euphoria or other mood changes, hallucinations, and effects consistent with central nervous system depressants or stimulants. The next guidance is entitled Deciding When to Submit a 510K for a Software Change to an Existing Device. And this document, or this guidance, actually supersedes the FDA's guidance deciding when to submit a 510K for a change to an existing device issued on January 10th, 1997. And in issuing this guidance, the FDA has attempted to define with greater clarity when a change in a medical device would trigger the requirement that a manufacturer submit a new pre-market 510K to the agency. And this guidance is not intended to supplement or implement a significant policy change to the FDA's current thinking, but rather it's intended to enhance the predictability, consistency, and transparency of the when to submit decision-making process by at least providing a less burdensome approach and describing in greater detail the regulatory framework, policies, and practices that underlie such a decision. And the next guidance is the use of real-world evidence to support regulatory decision-making for medical devices. In issuing this guidance, the FDA is attempting to clarify how it evaluates real-world data to determine whether it's sufficient for generating the types of real-world evidence that can be used in FDA regulatory decision-making for medical devices. And this guidance is applicable to all devices, as that term is defined under Section 201H of the FDA and Cosmetic Act, and includes software that meets the definition of a device. And with that, Lisa, I'll turn it over to you.
Thanks, Laurie. I'm going to talk about 3 additional final guidances that were issued this year. First, the de novo classification process guidance. The final document was issued on October 30th, and this guidance deals with the process for the submission and review of a de novo classification request, which provides a pathway to Class 1 or Class 2 classification for medical devices when general controls exist that provide a reasonable assurance of safety and effectiveness, but when there's no legally marketed predicate device. Devices in this category no longer need to go through a 510K submission and wait to get a determination of no substantially equivalent device. And the next guidance relates to interoperable medical devices. The final guidance was issued on September 6th, and this guidance is intended to help identify specific considerations related to the ability of electronic medical devices to safely and effectively exchange information and use exchanged information. It provides manufacturers with design considerations when developing interoperable medical devices, and also recommendations regarding information to include in pre-market submissions and device labeling. Next, we want to talk about the guidance related to manufacturers sharing patient information upon patient request. This final guidance was issued on October 30th as well. The FDA developed this guidance to clarify its position regarding manufacturers appropriately and responsibly sharing patient-specific information from a legally marketed medical device. The guidance provides information and recommendations about the mechanisms and considerations for device manufacturers that share such information with individual patients, again, when the patients request it. The FDA believes that sharing this patient-specific information with patients may help them become more engaged with their healthcare providers and make better and more sound medical decisions. And now, Laurie, I'm going to turn it back to you to talk about what regulatory activities we see on the horizon.
Okay, and I'll just briefly talk about the expedited pathway for approval of biosimilars or biologic products. And then recently there has been, or within the last couple of years, an expedited pathway that requires filing an application that contains information about the applicant's biosimilar, including analytical studies which show similarity to a branded biologic, animal studies assessing toxicity, as well as clinical studies demonstrating safety, purity, and potency. And it's anticipated that the FDA will likely approve the biosimilar if the application establishes similarity between the applicant's biosimilar and the branded biologic, it meets certain safety and efficacy requirements, and it allows inspection of the biosimilar producing facility. There's always the risk with some of these expedited processes or approval processes that there could be a greater risk for litigation, and the actual approval process itself may come into play. So far we haven't seen that, but it's something to watch for on the horizon. And I'll turn it back over to Lisa.
I think it's actually Sonia.
Sonia.
Yeah, and I get to talk to you about something that's I'm very happy to talk about. First, the FDA approved the first gene therapy for cancer. Hopefully this will be the first of many such advancements. Questions from a product liability viewpoint: is there a product or is this a service? We're really manipulating one's own cells and tissues. Will the strict product liability concepts and defenses apply? These are difficult questions to answer, but as these advancements prolong our lives and make them more useful, I think that the world of product liability is going to change.
Okay, I think I'm up for the next one, which is quality control of products combined by compounding pharmacies. And just by way of background, in 2013, towards the end of 2013, the Compounding Quality Act was passed in response to numerous serious events, including deaths, and everybody probably recalls the meningitis outbreaks that were linked to poor quality compounded drugs. And that law created a new category of outsourcing facilities that are seen as the primary compounded product suppliers to hospitals. It also attempted to clarify when retail pharmacies could send more than one compounded drug across state lines. Move forward 3 years, or a little more than 3 years later, and in January of this year, the FDA issued a progress report stating that oversight efforts have had a significant public health impact, but also admitting that it continues to be concerned about the risk to patients from drugs compounded by facilities that have unsanitary conditions. In terms of what we expect to see, the FDA is really expected to build on its initial efforts to implement and enforce the compounding provisions of the law in the coming months and years. And specifically, we expect this to include continued and vigorous oversight of drug compounders and, when appropriate, regulatory action. We also expect there to be further policy development to explain the regulatory requirements and increase collaboration with states and stakeholders. And now Sonia is going to address what we see coming down the pike in terms of litigation.
Thank you, Lisa. What to watch out for? I think the first bullet point, the expansion of mesh to include hernia and natural mesh products, is the first thing that I'll look out for. As of October 13th, there were 116 lawsuits in an MDL proceeding in northern Georgia. Ethicon, the target defendant, its product Physio Mesh is a composite mesh made of polypropylene and biological products. The first trial in the MDL in Georgia is expected in January 2018. If J&J's unit loses, then we're looking at the same groundswell as with pelvic mesh. We can expect a lot more cases. The second litigation on the hernia mesh is for Cook Medical. They manufacture purely biological mesh made from pig intestines for pelvic and hernia repair. Cook Medical has over 500 cases in the West Virginia mesh MDL. No cases have gone to trial against Cook, and many cases, over 100, have been dismissed based on Daubert motions regarding the qualifications of the plaintiff experts. Cases continue to be filed against Cook's biologic mesh product. They allege higher rates of infection. So yes, stay tuned on whether or not Cook will continue to prevail. Bullet 2, opioid litigation is just getting started. New plaintiffs to include more peripheral healthcare defendants or participants such as health plan administrators, labor unions, and more hospitals and clinics. Expect new lawsuits to include additional and untapped defendants such as pharmacy benefit managers and health insurers who opted to include certain opioids in their plans. These lawsuits will question pricing for opioids versus non-opioid substitutes. And then lastly, this is the one that I'm really, really concerned about for the future. Third-party private litigation funding is a real problem in the settlement of mass torts. Private third-party litigation funding is a $5 billion market in the U.S. It started in Australia as a way to fund shareholder derivative cases, but in this country has been used to fund products like liability litigation. In fact, a couple of mass torts involving pelvic mesh involve litigation funding. There is some prohibition against third-party litigation funding due to the doctrine of champerty, which bans third parties meddling in court cases by financially backing one of the parties. To get around these champerty laws, whose application has been significantly curtailed by the states, the parties agree to keep arm's length and have no control in litigation. The promise is one thing, but the reality is another, however. Firms such as Burford Capital are going to cause major headaches for those wishing to settle mass torts when they purchase a portfolio of cases from a law firm. These capital firms are looking for a 200% return in a very short turnaround. Their goal is to add as many cases as possible to an inventory so as to increase their overall settlement value. Unfortunately, these cases added are often minor cases with no exposures. It is up to the defendant to spend lots of money to separate the wheat from the chaff, i.e., separate meritorious cases from not meritorious cases. In addition, these private funders will often want to stay in the settlement amount and a review of the settlement agreement. This can drive up the indemnity or settlement costs of mass torts. Savvy defense lawyers are now serving discovery early on to identify those cases with third-party litigation funding and to keep their activities in check on those cases. And that's what I had. Now time for a question and answer session.
All right, thank you. We have had a couple questions come in, so I'll just start right in. I think this question is best for Laurie. Laurie, do you expect to see class actions in opioid litigation?
Well, I know there actually is already one filed, and I would note at the outset that pretty much anyone can file a class action. However, with the opioid litigation, we see particular problems with the issues of commonality and typicality of the claims that will make the cases hard to be certified as a class action, given a number of issues which could differ from plaintiff to plaintiff, including what drugs they're taking, what their drug history is, both be it legal and illegal, how long they've been using the drugs, any number of factors that could prevent class certification, and at a minimum can make it a very difficult uphill battle to get a class certified in the opioid litigation. And as well, Lisa, you want to talk about the other issue?
Yeah, I think when class actions, what's uncertain right now is the impact of the Bristol-Myers Squibb decision and how that will limit plaintiffs' ability to bring class actions, probably nationwide class actions, when they have plaintiffs from different states in one venue. So we haven't really seen that play out yet because the decision is so new, but I think that certainly defendants will be using that as a tool, as they should, to prevent not only mass tort litigation, but class actions.
Okay, thank you. Sonia, maybe you could opine on this one. Would it be possible for third-party or private litigation funding to underwrite some of the state's claims in the opioid litigation?
That's a terrifying thought, but there's no easy answer to it. There's nothing from a regulatory standpoint to prevent that from happening. A lot of the litigation, similar to the tobacco litigation, was from private law firms that were hired by the state. These private law firms ultimately are ripe for the pickings of a third-party litigation funder.
Okay, thank you. I think we're not going to take any more questions since we're a little short on time, but if you do have questions that we didn't get to, you've got the panelists' contact information on the slide, and feel free to send them your questions. Thank you, ladies. That was really insightful and a little bit scary, and I really appreciate your insight. I know our listeners do too.